Hello and welcome back to our special lecture series. My name is Taimur. I'm an attorney at law, and after having covered just the basics and highlights of certain constitutions, we are now going to be focusing over some of the most important constitutional cases in the history of Pakistan that even to this day are referred to and cited in various courts of law. And given their legal importance and historical value, a basic understanding of these cases is rather quintessential to understanding the various aspects and nuances of constitutional law. So in our last lecture we covered certain events leading up to the framing of the Indian Independence Act, where two separate dominions were established and two separate constituent assemblies were entrusted with the task of framing the future constitution of India as well as of Pakistan. So the constituent assemblies were basically performing two functions. They were A, performing the functions of a constituent assembly to frame the constitution, and B, operating as a federal legislature within the meaning of the Government of India Act 1935. Now, Quaid-e-Azam Muhammad Ali Jinnah, 3 days before the independence on 11th August 1947, became the first president of the Constituent Assembly, and after passing of the government of Indian Independence Act, he became the first Governor General. However, after his demise, Khwaja Nizamuddin became the second Governor General, and after the demise of Liaquat Ali Khan in 1951, Khwaja Nizamuddin chose to become the Prime Minister, because at that time it was becoming rather a norm that it would be a parliamentary form of government and Governor General would just be a figurehead. So when Khwaja Nizamuddin, the second Governor General, became the second Prime Minister, Ghulam Muhammad took his place and became the Governor General of Pakistan. Now, during the time frame, there were certain disputes, certain problems with respect to administration. There were certain anti-Ahmadi rights, and for failing to administer effectively, on the 17th of April 1953, Khwaja Nizamuddin was summoned to appear before the Governor General, and the Governor General asked him to resign. He refused, and so his government was dismissed along with the cabinet, which really sent a shockwave as to how the Governor General just deposed and dismissed someone, a Prime Minister with his cabinet. Under what power and authority has he chosen to do so? Now, on the other hand, in terms of the performance of the Constituent Assembly, in India it took not less than 2 years when the Constituent Assembly framed its constitution in the year 1949. However, in Pakistan, even after 7 years, by 1954, Pakistan didn't have a constitution of their own. And so right in 1954, when the Constituent Assembly, being led under its then President Maulvi Tameez-ud-din, was about to frame a constitution, there were certain amending acts which had the effect of taking away and curbing some of the powers of Governor General so as not to have the Khwaja Nizamuddin episode play up again. And so in response, as a sort of a reaction perhaps, on 24th of October 1954, through a proclamation, the Constituent Assembly was dissolved. And it was pronounced that till such time that new elections are held, a new council of ministers were to be set up. Muhammad Ali Bogra was not deposed, who was the Prime Minister then, but he was asked to come up with new ministers. And so just 2 days afterwards, on 26th of October 1954, a new council of ministers was set up, comprising of many members who were not even members of the federal legislature. And so against such actions, Maulvi Tameez-ud-din, who was then the president of the Constituent Assembly, filed a writ petition under section 223A of the Government of India Act 1935 before the Chief Court of Sindh, praying for the issuance of writs of mandamus as well as quo warranto. Mandamus to the effect that the court would issue an order not to give effect to the proclamation and would restrain the Federation from interfering directly or indirectly into the affairs of Maulvi Tameez-ud-din, performing his functions as President of the Constituent Assembly. And there was also a writ of quo warranto that which essentially challenged the appointment of the other members, because they were never members of the federal legislature, and this was against the provisions of section 10 of the Government of India Act 1935, which had been amended. Now when this case came up before the Chief Court of Sindh, the principal question was whether section 223A, which established the writ jurisdiction authority in Chief Court of Sindh, and whether section 10A, which imposed this condition that you have to be a member of the federal legislature, whether these two amending acts had received the assent of the Governor General, or were they just passed by the Constituent Assembly. And so ultimately the court ruled in favor of Maulvi Tameez-ud-din and held that so long as the Constituent Assembly performs its function in framing the Constitution, then it need not require the assent of the Governor General. Only when it is operating as a federal legislature within the meaning of the Government of India Act 1935, only then it requires the assent. So the ruling was in favor of Maulvi Tameez-ud-din. The central issue in the Maulvi Tameez-ud-din case was that section 223A and section 10, which formed the very basis of the writ petition filed by Maulvi Tameez-ud-din, were introduced in the Government of India Act 1935 by the Government of India Amendment Act of 1954, and it had only been signed by the President of the Constituent Assembly. It had as such not received the assent of the Governor General. See, they were following Rule 62 of the Rules of Procedure of Constituent Assembly, which stipulated that if any bill was passed by the Constituent Assembly, only a copy of which has to be signed, and it would take legal effect once it has been notified in the official gazette. And this practice had been followed since the period of Quaid-e-Azam Muhammad Ali Jinnah until 1954, and it is only now that this issue has been raised with such an alarm, which was in itself an enigma as to why all of a sudden this is being made the basis of it. So the Sindh Chief Court decided in favor of Maulvi Tameez-ud-din. However, this decision of the Sindh Chief Court was challenged in appellate jurisdiction before the Honorable Federal Court, which was the precursor to the Supreme Court, presided by 5 judges and the Chief Justice Muhammad Munir. Now, Chief Justice started his opinion by going back in history. He talked a little about democracy, institutions, constitution, a little bit about the Statute of Westminster of 1931, the essential distinguishing features in between a colony and a dominion. Now, there were 2 principal sections which may have gone and determined the whole case. There was section 6(3) of the Indian Independence Act, which said that the Governor General of each of the 2 dominions shall have full power to assent to any law passed by the legislature of the dominion. And then there was section 8(1), which said that the powers of the legislature of the dominion would be, in the first instance, as far as framing the constitution goes, exercised by the Constituent Assembly, and reference to the legislature of the dominion shall be construed accordingly. So, giving a combined reading, Chief Justice Munir held that when the Constituent Assembly was even framing the Constitution and exercising its powers under section 8(1) of the Indian Independence Act, it would still nonetheless be subject to the trappings and to the restrictions, because section 6(3) came as a form of restriction in the Indian Independence Act, and since section 6(3) states that the Governor General has the power to assent, it would also imply that he has the power to withhold his assent. And since his assent was not obtained, as such these respective amendment acts would have no value. Now, in order to support this holding of his, that the Governor General also has the power to withhold, he gave his opinion that the Crown has essentially been part of the British Parliament since time immemorial. And since Governor General is a part of the Crown, he is a nominee and appointee, you cannot exclude him from the lawmaking process. He also talked about the prerogative powers, the inherent powers which inhered in the person of the king, that he could dissolve, summon, prorogue any assembly. And even though the last time he dissolved a king or sovereign was in the time of Queen Anne, and it has not been done so, and the constitutional practice is that maybe he can on the advice of the ministry. But nonetheless, the process of lawmaking, the Royal Assent which is given when a bill has to become a law, that assent is as much a part of the prerogative as is an inherent power. and it vests within the office of the Governor General. More so, since under Section 8.2 and 8.3 of the Indian Independence Act, it was made clear that the Government of India Act 1935 would be, for most part, the constitution of Pakistan, with certain modifications, additions or changes which would be made by the Constituent Assembly. And since Governor General had those reserve powers under the Government of India Act 1935, who would nonetheless be entitled to use them, and this power to withhold assent formed a crucial power, a part of the power of as such giving assent to anyone. There were also certain arguments that this is an independent dominion. He said that if there is a statute of Westminster 1931 that has, because most of the provisions were copied from this enactment, so it cannot be above even the act, or it cannot be entitled to the freedoms beyond the scope which has been rather laid out in the Statute of Westminster Act 1931. Now there were also certain arguments presented on the question that this legislature has failed to perform its duty after 7 years. It has still failed to frame the constitution, and there were certain paragraphs where it was laid out that once a legislature becomes perpetual, if it was once corrupted, the evil would be past all remedy. And so in these situations, the head of the state, the sovereign, whoever may be, must possess this inherent right to dispose, to dissolve the Constituent Assembly, because there was one major lacuna in the Indian Independence Act, which was that there was no expiry time as to when the Constituent Assembly would be dissolved. And so if in the event it failed to frame a constitution, there must be some way of getting rid of it, unless this perpetual legislature is to govern for all times to come. And so this decision, which was given by the Chief Justice, overturned the earlier decision passed by the Chief Court of Sindh. An interesting point of the Maulvi Tameez-ud-din Khan case was that though the 24th October 1954 proclamation set out reasons for dissolving the Constituent Assembly, namely that the constitutional machinery had broken down and that the Constituent Assembly had lost the confidence of the people, these reasons were never looked into, addressed or dealt with in any way by the majority judgment given by Chief Justice Munir. Rather, the decision was given on basis of mere technicality, that since Section 223A had never become law, the writ prayed for could not be issued. So it was a decision which was made on basis of technicality rather than on merits. Now, of the 5 judges, 3 of the other judges supported the majority judgment of Chief Justice Muhammad Munir. However, A.R. Cornelius gave his dissenting note, and his reasons for giving a dissenting note were that it would be against the very mantra of demanding a separate Constituent Assembly, that if the Constituent Assembly, which now has come full circle, and whatever law it passes still has to attain the assent of the Governor General, who otherwise is an ancient relic who is appointed by His Majesty, then it really goes against the very purpose of having an independent Constituent Assembly. He reasoned that the Constituent Assembly was a supra-legal power, that it was not just a creation of the British Parliament, and so it couldn't be subjugated, couldn't be subject to the limitations placed or set out under the Government of India Act 1935 or the Indian Independence Act of 1947. Rather, the Constituent Assembly, if it wanted, it could replace, it could repeal, it could change everything it wanted to. So how could it be under such enactments? Furthermore, he was of the view that the Constituent Assembly was an independent dominion. It was different from the dominions of South Africa, Australia or New Zealand. The language which was employed in those enactments was of the effect that the Governor General could exercise his powers in his discretion. Rather, no such language could be found under the Indian Independence Act, and a Constituent Assembly was to be framed, which was something not present in some of the other dominions, that it could frame its own constitution and it could get away with all the limitations, all the restrictions, if any, remaining under the Statute of Westminster Act 1931, if you may, to this effect. And so he reasoned, he held in a way that he would place the Constituent Assembly above the Governor General for 2 main reasons: that the that the Constituent Assembly, number one, was a sovereign body, and number two, that the very enactments under which the Governor General was to operate were within the legislative competence of the Constituent Assembly. And so this is a supra-legal body that we are talking. It does not require the assent of the Governor General. Now, furthermore, the Governor General himself, he owes nothing to the British Parliament, to the Crown, except for his warrant of appointment. In fact, there was the famous oath ceremony when Quaid-e-Azam was to take an oath. The language officially which was required to be taken was that I would bear full faith and allegiance to His Majesty. And Quaid-e-Azam changed that language, and it was changed to the effect that you would bear allegiance to the Constitution and be faithful to His Majesty. Now, furthermore, there was a lot of discussion about Rule 62 because Chief Justice Munir felt that a rule of procedure cannot change a substantive part of the Constitution. And even if the first two amending acts that had been followed through in pursuance of Rule 62 had come before Quaid-e-Azam, they wouldn't matter because Quaid-e-Azam back then was not just the President of the Constituent Assembly, he was also a Governor General. However, A.R. Cornelius, Justice, was of the view that apart from just this Government of India Amendment Act 1954, many other important legislative enactments, whereas the power defense to raise, maintain armies, this was introduced in the Government of India Amendment Act of 1950. The Delimitation of Constituencies Act was introduced in 1951. So there are so many other important legislative enactments under which so many new rights have been created. How can you say that these respective amendment acts as such are of no rule, are of no use? And then apart from Rule 62, there were many other rules, such as Rule 6 or Rule 6p, which dealt with how the President of the Constituent Assembly could disqualify someone or could fill vacancies, that the President of the Constituent Assembly could declare that this person is disqualified. These rules were never created under the Indian Independence Act. These were internal rules that had been followed, and relying on Kohli's interpretation that if no other mechanism is provided and if you keep on following a certain system over time, then it kind of does attain the status of law. So overall in all, this judgment, this view which was given by A.R. Cornelius is still to this day remembered, and historians look back and feel that this judgment was given rather in haste, and it undermined the institutional capacity. It weakened the institution, especially at a time when Pakistan was at a nascent stage. And the interesting thing was that in the year 1954, the Constituent Assembly was almost ready to bring forth this new constitution which had taken so long. So it was just about to be passed. And whereas in India, when they passed it in 1949, they didn't receive the assent of the Governor General, they passed it right away. So the historians look back and view this judgment to perhaps have been given in haste or maybe under pressure. But again, the irony was that Ghulam Muhammad, who was the third Governor General, just shortly, a few months after, he fell sick and he had to go to United Kingdom for treatment, and so he put in place his Interior Minister Sikandar Mirza in charge as acting Governor General, who only replaced him 1 year after. And sadly, Ghulam Muhammad, the third Governor General, under whose pressure perhaps this decision may have come forward, died and passed away just 2 years after in 1956. So I think we're going to cut short our lecture here today, and in our next lecture we're going to talk about the famous Yusuf Patel judgment, and I hope that we have brought out some interesting points. Thank you.